going on? How's everyone doing?
Shout out to Colin. Everybody else who's cool with Colin.
Chucky, I didn't say.
Get your popcorn and your Coca-Cola and relax.
Anyway, tell Colin I'm ready.
What's going on? This is Colin. How's everybody doing? Happy Sunday. Hope everyone's doing well. Hope you guys had a great weekend. You guys want to watch some court? I want to watch some court. All right. I've got a random collection of clips for you guys tonight. Probably going to do two different videos. The first video is the random, and then we've got a second video that I was setting up to do a premiere this afternoon, and yeah, I just didn't. I just waited till tonight, put them both out at once. All right. Before I hit that play button, you already know what to do. Hit the like and subscribe. Do your jump kick backflips. Let's go. All right, before we get started, Kelly, member for 3 months. Thank you so much. That is awesome. Thank you. I appreciate it. Okay, now let's go.
You go get his attorney real quick.
All right. Right back to Judge Simmons. This guy got himself into trouble. Now, this is, he already had his hearing, and this is what happened after his hearing. Just so we're on the same page. His hearing wasn't anything too exciting, so I just kept that part out of it. This part's kind of funny. Lizette, thank you so much. Another member for 3 months. Thank you. I appreciate it. What's up? Isn't that special? All right, where's his attorney? I thought this was only about a 10-second pause. I don't want to spoil it and tell you what he did. But he violated a bond condition about 10 seconds after it was given to him. All right, we're getting to the point where I got to fast forward.
Mr. Lee, I need to go back on the record on Keene.
Very well, Your Honor. I'm on my way.
Thank you.
Okay, I'm just going to fast forward. I'm going to jump up.
Mr. Keene, it's
Oh,
come to my
perfect.
attention that both on your way in and out of the courtroom that you had communication with the victim.
That's what I love it. That's my wife.
Do you understand what a no contact order means?
I'm supposed to have contact with her, yes.
Yeah, that means you can't say anything to her.
Oh, I didn't know if it speak.
Oh, you don't know what no contact means?
I thought there was no physical contact as far as,
Who said physical contact?
well, I didn't really understand what it meant then.
You got a copy of your bond?
No, I don't, Your Honor.
Okay, you also have a bond violation for having unauthorized communication with the alleged victim. Is that correct?
Yes, I do, Your Honor.
Okay, let me make this extremely clear for you. You're not to have communication directly or indirectly with the alleged victim, Deborah Woolison. You can't send a smoke signal, a text message, write a piece of paper, no communication of any kind. You can't wink at her, stick your tongue out, put your middle finger up. 0 things can be communicated. Do you understand? If she's sitting next to you, you look the opposite way. You understand that? You have pending charges for domestic violence, and then now a pending contempt of court for a bond violation. And I'm going to add a second contempt of court, because right after I denied your bond, you went out there and you said something again. And I don't think you're that stupid. You know exactly what no contact means. No one said no physical contact. Nobody told you you couldn't touch her. We say you couldn't be within a certain amount of feet of her. You can't have communication directly or indirectly. You can come in here and play dumb if you want to. It's going to land you in jail for 93 days. Do you understand that? That's why your bond was denied. That and the allegation that you're using illegal drugs while out on bond. Bet you didn't understand that either, that part of your bond?
I didn't understand that.
Oh, okay, thank you. I'm gonna, again, reiterate, there's not to be any communication directly or indirectly between you and the alleged victim. I'll leave it to the prosecutor's office for them to pull your records and find out what's going on while you're sitting in jail. Do you understand that? Do you have any questions to help you further understand the bond conditions?
No. I got sentenced to 93 more days though.
No, you're facing additional 93 days. Do you understand that?
Yes, I did.
Do you have any other questions?
No.
You can be excused.
All right. For those of you that didn't catch it, as he was leaving the courtroom, right after he was told not to have contact with her, he said, "I love you" to her because she was in the courtroom. She was there for it. And he said, "I love you" to her. And as he walked out, and the court officer immediately just walked in, told the judge, like, "Nope, bring him back." Nope. And that's where that speech was. That's what happened. Okay. I am paused. Hello, Rachel. Good to see you.
All right, you're all set, sir.
Thank you.
All right, thank you. Miss Boyce.
Yes, ma'am.
All right, this is 220902, 221981, 24TA02083B, 240344, and 240343. Mr. Fantos, can I get your appearance?
Jeffrey Fanto on behalf of Ms. Boyce.
Miss Boyce, you were supposed to be here at 10:30 a.m. and you weren't here.
I know, excuse, I'm so sorry. I thought it was tomorrow. That's why I called right away when I figured it out.
What time did you call?
At 12:30.
Well, we had complaining witnesses present on these cases today, and they sat here waiting for you to show up on these cases. One of these cases, you've been in warrant status twice on. That's 0902. You had a payment plan. I give you a payment plan of $50 a month. Have you been making payments?
No, I haven't. I don't have a job right now. I've been looking, but I've been helping my daughter take care of her baby, but I've been looking for a job. But see, I don't have a car, so I gotta look closely, a place close where I can walk to or take a bus. And so it kind of lowers my, places to get a job.
Yeah, well, I think you're a flight risk. You don't come to court. I have another one from November of 22 for an assaultive crime that you never came to court on. And you've been in bench warrant status on that for 1 year and 3 months. Like, you don't show up. You've got tickets that are unpaid. You're driving a car when you're not supposed to. You just you want the court to make all these exceptions for you. You've got a criminal history dating back to when I was in high school. Your criminal record starts when I was 16. And you don't seem to take any.
How do you call someone old without calling them old? Bring up their criminal record started when you were 16. I mean, that's one way to do it.
This seriously?
No,
and you
yes,
don't
I believe me, I take it seriously.
No, you don't take it seriously. You've been in warrant status for years on assaultive cases. That's a fact.
Well, that one will get dismissed because I did not hit her. My daughter's not going to show up for court because I did not hit her. She lied.
You could turn yourself in person. You could turn yourself in. We could set you a court date. You have $100 bond on the $100 cash bond on the driving while license suspended. That's 24034302. And you need to come up to court and pay that.
Yeah. I could probably do that on probably around the 15th. I can get the money for that.
All right. Well, you'll be in warrant status until that time.
Okay. But I could just go into the courthouse with the $100 and then
yeah, and then you'll come see me, and then we'll set a court date.
Okay. Do I go to the police station with the money, right? Or do I go to the courthouse?
No, you come to the court, ma'am. You come to the court.
Okay. Okay.
You're all set. You're in warrant
Okay, thank
status,
you, ma'am.
and you'll remain in warrant status until you come into the building.
Okay,
Thank you, Judge.
thank you, ma'am.
Yeah, Judge Shackelford was not happy with her at all. You will be in warrant status until you turn yourself in. Karen, thank you so much for being a member for 2 months. I appreciate it. Thank you so much. That's awesome. And Kathy donating 5 memberships. Thank you, Kathy, and welcome to the new 5 members. Hopefully the whoever just said I can scroll up to see maybe their name turned green. Oh, it doesn't. Maybe it's because I don't know. I don't know if they got one. Hopefully you did. Hopefully you did. All right, yeah, you did. Good. Yeah. See, your name's green now. It still doesn't show up green when I bring up the chat though. Okay. All right. Thank you guys. You guys are awesome. Okay, let's go.
Mr. Welch.
All right, this is 21230, the people
Read his shirt. Read this guy's shirt. This is a good shirt to wear in court, right? I mean, it's not the worst.
versus Daquan Welch.
Good afternoon, Your Honor. James Kazicki on behalf of Mr. Welch. Waive reading of the complaint, stand mute. Your Honor, Mr. Welch has a current address listed on the advice of rights form, indicated he moved from his address of record about 4 years ago.
All right, well, we should have let Secretary of State know that. He also was on bond. He's, I don't know when he moved, but I can tell you he's been in warrant status. Then he gets picked up, then he gets another personal bond or a low cash bond, and then he absconds again or doesn't get his mail. It's an assaultive crime. He's been in bench warrant status 3 times. Sir, you're here.
I was more referring to the fact that it says I'm sorry. That's what I like about it. He's saying he doesn't have to say he's sorry for everything he's doing right now. He's already, his shirt says it. Also, hi Heather.
For failing to appear at prior hearings, you're in warrant status because this is an assaultive case for domestic violence dating back to May of 2020. So almost 4 years we've been waiting for you to come to court. You have a $5,000 cash bond, or you can post 10% with a GPS tether. You're to appear in court as directed. You're not to leave the state without permission of the court. You're not to commit any new crimes while released. You're to immediately notify the court of change of address or phone number. You still cannot have any contact with Ms. Peterson, her residence or employment. And you cannot possess or have access to firearms. And we'll get you a court date in the mail. I've marked the file so they know to look at the register or the advice of rights for your new address. All right. We're all set.
She said something about Secretary of State being updated and notified. They've been updated of the address that I was staying at. It's on my ID, my plane ID.
Sir, one of your bond conditions has always been, and I've looked at them in the file. I'm not your judge. One of your bond conditions has always been to notify the court of change of address or phone number. If you have a criminal case pending, I don't have to tell you you need to come to court. You know you have a case pending. So when you decide for 4 years to show up when you get arrested and otherwise not appear for court, the consequence of that is you get a bond that will assure you'll show up, which is what you just got. So we'll see you soon, sir. You're all set. All right. This is 2-4.
All right, like I said at the beginning, these are all pretty short clips. I think the longest one is 8 minutes. And I think we may have already seen that one. Also, Legal Fiction tried to drop in a membership milestone right when I ended stream last night. I saw it, but I already hit end stream and then it popped up. So, but I don't remember. I think it was, I don't even want to guess. Because I don't remember what the number was. But Legal Fiction, thank you so much. I appreciate it. I did not miss it. What's up, No? How are you, buddy?
Stephen Johnston. Good morning, Aaron. Alex Green on behalf of Mr. Johnston. I'm requesting permission of practice pursuant to MCR 8.120 under the supervision of Attorney Lauren Brown.
Really? Okay, permission to practice is good.
Stephen Michael Johnston, Your Honor. How are you?
Thank you.
This morning.
I'm just wonderful. Yourself?
I could be doing better, Your Honor.
Yeah, I know. Sometimes it'd be that way. Go ahead.
Your Honor, we're asking the court to set the matter for a preliminary examination.
All discovery is complete.
Yes, Your Honor.
People have the witnesses available on the 16th. Preliminary examination will be set April 16th in person. 9 a.m. before Judge Fresh Hour.
To be heard on bond. Good time.
Yes. Go ahead.
All right, I've said this before. I know I've said this a couple times. When the prosecutor brings up a bond argument and the defense doesn't, that means you messed up. Just saying, you did. You messed up. Also, thank you so much, Michelle. You know what? I'll get the memberships during the break. I'm gonna try to do that better.
Point one is the amount of his bond, and two are his phone calls. First, at the time that I charged this case, I requested a $50,000 cash surety bond. The magistrate set his bond in the amount of $40,000, 10%. I'm requesting. I'm the
40,000.
40,000, 10%.
Okay.
I don't know. Yeah. But I'm requesting the 50,000 again. The defendant is charged with strangulation and domestic violence. There may be an additional charge of possession of meth coming as well. The suspected meth that the defendant had in his backpack upon arrest is currently at the lab. If we get those test results that come back meth, we'll be charging that also. But in this case, the defendant used one hand, put his hand around the victim's neck and strangled her. He then put his other hand into her face, covering her mouth and her nose. The lethality report that the police filled out reflects the victim is struggling to breathe while he was doing this. Prior to strangling her, he had hit her in the face with a plastic fan. And the police were able to observe injuries to her. She had redness to her neck, and she then received medical treatment. The defendant also has 1, 2, 3, 4, 5 holds. 2 are from Trenton, 1 is from Lincoln Park, and 1 is from Dearborn. Those 4 are all traffic offenses. However, he does have a Dearborn Heights domestic violence hold with a $500 bond on that. I don't know the circumstances of that domestic violence case, but I'll be reaching out to them to get a copy of that report. So first, I'm requesting that the bond be increased to $50,000. Yesterday, I received notice from an intern that works in our office who had the opportunity to review all of Mr. Johnson's jail calls. And the intern sent me a memo about 8 of the defendant's jail calls. I immediately reached out to Mr. Warren Green. I downloaded the 8 jail calls and sent those to Mr. Warren Green. And I had the the Sheriff's Office Record Department yesterday send Mr. Warren Green all of the defendant's jail calls. So they've had access to them for almost as long as I have. In the 8 jail calls, placing calls to the victim despite a no contact order with the victim. They are discussing this case in detail. They've discussed the victim changing her story. The victim is going to take responsibility, that she's going to say that she remembers things differently. The defendant directs her to call the prosecutor's office and, I quote, be on their ass a little bit, make them drop the charges, tell them that you want this dropped. As if Ms. Barroso was here, she would say that he then engages in love bombing, telling her how much he loves her, that he wants to marry her, that he wants to put a ring on her finger, that he just wants to get out of jail, tell the prosecutors to drop the charges. My office has been in contact with the victim to continue to offer her support. The officer in charge from Ann Arbor yesterday was also in contact with her to offer her support as well to allow us to move forward with these charges. My office is into whether or not we will be filing a forfeiture for wrongdoing against this defendant should this victim ultimately decide to tell us a different story. However, based on the supports we're providing her, I'm hoping that is not the case. And we're also looking into witness intimidation against the defendant. So A, please increase this bond to 50,000 as I initially requested, and B, will revoke his jail call privileges as well. Thank you.
Response.
Thank you, Your Honor. As Ms. Hughes said, she did send those phone calls over to me yesterday. I had an opportunity to listen to those. I had an opportunity to speak to my client. Mr. Johnston understands that any contact with the complaining witness is a violation of his no contact order. He assures me he will not contact her whatsoever moving forward. Our only request is that the court retain the 10% privilege in his bond. If Mr. Johnston were to post, he would reside with his grandmother in Redford. He was employed fully before this as a sales rep at AT&T. Mr. Johnson has 2 children and only has 1 prior conviction on his record for a traffic.
Just to, maybe I didn't understand what you said. He has a 2023 domestic violence conviction.
Your Honor,
And Your Honor, I apologize. If that's true, all I can see in his Michigan criminal history is 1 prior conviction for the traffic matter.
Your Honor, may I speak, please?
We have an attorney. If you want to, you can go ahead.
Your Honor, I was not aware that I wasn't allowed to contact my fiance.
Really?
No, I didn't. When the video during the court in the inside of the jail cell has been glitching.
And Your Honor, Your Honor, he's
When the magistrate was saying.
But I am aware now, Your Honor, I am aware now that I'm not allowed to contact her whatsoever. But I did not love bomb my fiance whatsoever. My fiance openly in the state.
Stop it. Your Honor, I think what Mr. Johnson meant to say is there were no
Oh,
threats.
what he meant to say what?
He was absolutely not threatening any witness in the case.
No, I wasn't. Not
Was he
whatsoever.
telling her to change her story?
No, I was not. She openly, you can listen to the call.
Oh, you don't want me to do that.
No, but I'm telling you, the very first phone call with her, openly admitted to it. I didn't coerce her.
Your Honor, we're asking to proceed to preliminary exam.
Yes, miss. There's more. Go ahead.
No, just to be completely candid with the court, I said it as a conviction. I'm sorry. In 2020, he was bound over in Wayne County on the domestic violence and child abuse charges. I said it was a conviction. It just says bound over in the judicial segment. I apologize. I need to be clear. I don't know what the ultimate outcome of that case was.
Your Honor, my understanding is that case is set for trial in May.
He was out on bond in felony child abuse charges. And
When this occurred.
thank you.
Anything else?
Nothing from the defense, Your Honor.
I would find that I'm not sure where the 40 comes from, but whatever. I find that the 10% is an abuse of discretion, given all of the circumstances. The defendant's, the 10% privilege. I will not raise it to 50, but it'd be $40,000 cash surety. Will be his bond. Further, it was clear, and it was less than 10 days, well, less than a week. This defendant was arraigned, and all of this has occurred, and the phone calls have been listened to, and he shouldn't have been in any contact whatsoever with her. Just plain and simply shouldn't have been in any contact regardless of the contact. Defendant's phone privileges are hereby revoked in their entirety. Thank you.
Thank you, Your Honor.
Thank you, Your Honor.
All right, yeah, that was a bad case of FAFO. Went in there with the $4,000 bond, left with an increase from $4,000 to $40,000. I mean, he had a 10%. I don't know what you call that. So yeah, 10% of 40 is 4. So yeah, it raised $36,000. Math. All right, I am Let's see. I think I was on Michelle. Michelle, thank you so much for the 3 months. That is awesome. Thank you. Thank you. I appreciate it. Cross, member for 1 month. Drop in for another pause. Thank you so much. Thank you so much, Cross. I appreciate it. And congrats on the 1 month. Lizette, hi to Colin and all of my wonderful peeps in Discord. Brought to you by Fozzie's cat who stole Fozzie's wallet. Fozzie's cat is always very generous. And Dick Harris, thank you so much. Hi, y'all. Great to see you. Thank you, Colin, mods in chat. Thank you for the 5 months, Dick Harris. Thank you so much. You are in the top, 1% of the members. Thank you. And then Jedi, thank you for the 3 months. I appreciate it. And congratulations. Thank you to all the milestones. And I just saw Fred jump in. Welcome, Fozzie. Good to see you. Hey, Courtney. Good to see you as well. All right. Let's keep going. Oh, we're back to Simmons. Judge Simmons.
Who's representing him? What do you need, Judge? Okay, have you spoken to him? Because if he doesn't know how to appear via Zoom, then I'm going to bench warrant him.
I did speak with him yesterday.
I don't know what's happening here, but
I don't as well.
it's making me uncomfortable. So I don't know if you want to call him, tell him that if he's going to appear via Zoom, he needs to appear appropriate. I don't need to see his bare feet. He needs to be sitting upright, ready for court. He's supposed to be in person because he has a preliminary examination and he has a bond show cause.
I'm aware, Judge. I will let you know.
All right, she was talking about someone who's appearing by Zoom. I think you guys figured that out, but I was just clarifying.
Okay. On the record in the matter of the people of the state of Michigan versus Wendell Aldridge, file number 24-00221. Appearance, please.
Assistant Prosecutor Paige Petrosky on behalf of the people. Aaron Robinson, Assistant Public Defender for Mr. Aldridge.
Okay, Mr. Aldridge, can you unmute your device, please? Let me do this. You have to unmute.
Okay, I just did that.
Yeah. Apparently he was like laying down and his camera was on his feet because that's what she was saying. I need him to sit up. He's laying down and I don't want to see his feet. That makes me uncomfortable. That's what she said. So we don't really know what happened, but I think we can figure it out.
Okay, why are you not in court?
Well, I'm still up under like some conditions of being ill, and I tried to explain that to my attorney, and I also talked to I cannot remember her name, some lady from the courts, and she told me to email her, and she told me to make sure if I did Zoom, make sure that I sent her some paperwork from the hospital around about 2 or 3 to show that I do have this problem.
Did you send proof that you had COVID?
She told me to make sure. I told her that my people that's going to get the paperwork will be off of work around about 2, and around about 3, I will fax it back to the thing that I faxed to her yesterday. Not fax, but email.
You have paperwork with you right now that indicates that you're currently positive for COVID?
No, I didn't I had some paperwork though, but I went back. I didn't call it again. This is my 3rd time.
Well, my question is, do you have paperwork? My question is that do you have paperwork right now?
No, ma'am.
Evidences that you, so how are you going to send us something at 2 o'clock if you don't have anything that says you have COVID? Did you go test for COVID?
I'm gonna go. What I'm saying, Your Honor, that I'm gonna go up to the court, get a ride up to the courtroom, and get more paperwork.
I'm confused. Do you have COVID right now?
Yes, that's why. Yes.
Okay.
I'm sick.
And you're gonna ride up. You're gonna ride up to the court later on at 2 o'clock with paperwork.
Well, no, I'm gonna have my people go get it. I'm gonna call the Sparrow Hospital and ask them, can they release my paperwork to my sister, my older sister,
okay,
so I can send this paperwork over to the lady who told me that I
Sparrow's not gonna release any paperwork because you called them. Did you go to? When did you go get tested?
About like a week ago, about a week and a half ago.
Then you don't have COVID right now because there's no requirement for you to quarantine for a week for COVID.
Well, I still feel sick.
Okay, well, you're gonna
Still
get a
have-
bench warrant for failure to appear. Any additional matters for today's record?
Nothing from no, Your Honor.
Thank you. You're all set.
Okay. I think that's something.
Ooh, be careful what you say under your breath there. If I can hear it, so can the judge.
You're a bench warrant with the remand too. Thank you.
Bench warrant with a remand. Yeah. You can't use the I'm sick for court. They're gonna be that mean boss that makes you bring in a doctor's note. Sorry, man. You can't just say I'm sick. You can't. It's not 2020. Was that when the pandemic was? I don't even remember. 2020, 2021? Somewhere around there. Yeah, that worked back then. It doesn't work anymore. Still skating with that excuse. All right, all caught up on super chats. Okay, let's go. All right, we're finishing this video out with Judge Middleton. Like I said, I'm going to play 2 videos tonight because I'm going to play the premiere that I slacked on this afternoon and didn't release it. So I'll play that right after this one. This is a little bit of a longer hearing, though.
Good morning. Good morning. Don't look so terrified. Nothing terrible is going to happen here.
All right.
Is this like a deferral, Melissa?
Yes, Your Honor, a delayed sentence.
All right. This is file 232425SM. You're Gary Everstein.
Yes, sir.
Mr. Everstein, you got charged with obstructing a police officer by disguise and retail fraud in the 2nd degree. Let's look those up.
I looked him up because a lot of people have been saying his name recently. I looked him up. He is not on YouTube. He is actually on he streams a different way. That's the only thing that I found with him. So, and it's kind of a weird setup. It's one of those setups that you have to watch all day long. And I don't know. I haven't played around with it too much yet, but yeah, it's not on YouTube unless somebody has the actual YouTube link. I have not found him on YouTube. I just found him from a link from his courthouse's website. But I did look him up because a lot of people have been saying his name. Nope, not going to do it. I don't fall for that time, lady. But thank you for the super chat. And yeah, well, I'm not going to pause it just because you told me to. Oh, wait, I already paused. Thank you.
It's alleged that you were at Walmart, #1 stealing place in St. Joe County is Walmart and 3 Rivers. And you took some property worth more than 200, but less than 1,000. And I'm not sure what this disguise was about. Both of those are misdemeanors punishable by up to a year in jail and a fine of up to $1,000. Prosecutor has agreed to reduce both of those to a charge of retail fraud in the 3rd degree, 1 count, which is punishable by up to 93 days in jail and a fine of up to $500. They've agreed to defer the sentence, set it out about 90 days, and have you do our retail fraud deferral program. And if you do that, the charge would be dismissed and there would be no criminal charge on your record as a result of this incident. Do you understand?
Yes, sir.
I went through the advice of rights just a minute ago. Do you understand you have all those same rights?
Yes, sir.
Other than the plea agreement here, did anyone promise you anything to get you to plead to this?
No, Your Honor.
Your Honor, did you mention that restitution is part of the plea?
4172.
Yes.
Thank you, legal fiction. Pause for thought. There you go. I was trying to put it in the middle of someone talking.
This is a common thing that I rail against, underscanning. But according to this, you got some jumper cables and you put a Nerf toy sticker on it. And the jumper cables were worth $45 and the sticker was worth $3.15, which leaves a shortfall of $41 and some. You understand?
Yeah, Your
Is that what happened?
No, I grabbed him. I was in a hurry. I just got out of work, just got paid until Friday. You know what I mean? And I put $100 in the machine and grabbed my change, threw it in there with the receipt in the bag and walked out.
All right, is this the only thing you bought?
Yeah, that's the only thing I bought. So I didn't even notice like how much change I got out of the machine.
I remember that story. He's claiming that he's not the one who swapped the sticker.
The affidavits.
So he's not the one who swapped the sticker. He scanned the jumper cables, threw in 100, didn't count his change because he put in 100, just put the change in his pocket and walked out. Now, that I can see that happening. He says he's in a hurry. I don't know. You're still looking at the screen while it's processing, though. You scan it, you put it down, you hit ready, and while it's saying, switching from scan mode to pay mode, you'll see what the price is. So I don't really believe that, but just wait.
Quite brief. I don't know if there's more in the police report. Well, yeah. So, did you buy a Nerf toy?
No, Your Honor, I did not.
So just the jumper cables?
Yeah.
Does the police report have any more than the affidavit in it, Melissa?
Yeah, one moment. Although last time I sent it to you.
Well, it did eventually get here.
Did it? Okay.
Yes. Mr. Eberstein, you've also got an unpaid traffic ticket.
Yes, sir.
And they used to suspend your driver's license for that, which I was fully in favor of. But they stopped doing that. You owe $220 on an old no proof of insurance and no ops.
Yep.
So you're gonna need to take care of that.
Yes.
The last time I was at any kind of self-checkout for, anything more than just a couple items. Well, no, it was only 2 items. That's when I go to self-checkout, is when I only have 1 or 2 things. But they were 2 different size roasting pans, and they were both like $15 each. And when I scanned them, the total came up to like $16. And so I didn't pay. I instantly flagged someone down. I'm like, this isn't right. These are both 15. I'm not doing this. I see this all the time that, this wasn't my fault. I didn't do this. This is not $16. It should be closer to 30. And they're like, oh no, it's on sale. You buy 1, you get 1 for $1. I'm like, where? Okay. All right. You said it, not me. I'm not in trouble. Bye. But yeah, I noticed the price difference. So yeah, you got to pay attention.
All right. What do you do, sir?
Construction,
Who do you work for?
all trades in Chipswana, but I'm working in Elkhart right now.
What do they do?
Build factory.
Is that an Amish shop?
Kinda. He used to be Amish.
Hey, There it is.
The first report's more about the disguise, the second supplemental is the retail fraud.
All right, Judge Middleton found the police report. Now he's gonna read what really happened. Yeah, it's not gonna end well for that guy. Well, okay, I'm just gonna stop there.
And then we have a copy of the receipt, Your Honor, that indicates that he paid
Hey,
with
Brad,
a $10 bill.
by any chance,
Jumper caber,
are you
jumper cables.
this afternoon
that
doing
would
the
normally
warrant?
All right, I was wondering if I had an editing mistake in here.
The first report's more about the disguise, the second supplemental
All
is
right,
the retail
there we go.
fraud. And then we have a copy of the receipt, Your Honor, that indicates that he paid with a $10 bill for jumper cables that would have normally cost $45 almost, not $100 bill.
I think we can craft a little bit more of a basis relating to kind of recklessly.
Well, I want him to tell me the truth. I'm inclined to like just have her withdraw the plea deal and just give you about 90 days in jail. It's one thing to be a thief. It's another thing to be a liar. And a
Yeah, I was just in a hurry that day. I was like I said.
All right, so,
My vehicle broke down.
okay. Now, then you gave him a false name and
There's a bit of an explanation for the false name if you'd like to hear it, Your Honor. Mr. Eberstein was adopted. He was born as Gary Engelmeyer.
all right.
Was adopted as a child and kind of uses both names, and he actually provides us that as part of a registry. that he's
Okay,
listed on.
got you
And
there.
I was
All right.
trying to talk to the officer. He just wouldn't hear anything I had to say.
Well, that charge is being dismissed.
Correct.
So let's take a
I still call BS on that. I mean, I understand, you being confused with your names when you're adopted as a kid. If you have your name legally changed, I mean, I understand that as a kid. This dude's an adult. He did that specifically not to try to get out of being in trouble. I don't believe that for 1 second. So Tater Todd, thank you so much. At least it wasn't from the soft sit treasure fund. Yeah. Thank you, Tater Todd. I appreciate it.
look at the other part. I wish I would have been more with it with Miss Comer because she's got a bunch of unpaid stuff. The other report hasn't got here yet. Did you send me two?
No, just one, and they're both in the same.
All right, let's take a look. Well, it's all being dismissed if you hold up your end of the deal, but I understand perhaps the confusion about the name. You don't carry any ID?
Yeah, it was out in the car, and so I was trying to tell him I'd go get it if he'd let me, and he wasn't hearing nothing I had to say. Not a word.
Use a $10 bill.
Yeah.
Yeah, you're in this up to your eyeballs, but I'll do the deferral. You didn't use a $100 bill. You used a $10 bill to buy a $45 set of jumper cables that you didn't have enough money for. So, all right, let's set this out for sentencing. We do have $100 of bond. That's a plus. Set it for July 8th at 10:30. I want you to do the economic crime class. pay $42 restitution to Walmart from bond, 10 hours of community service. You're barred from Walmart. And you'd also pay your traffic ticket.
Tracy, I was actually wondering how expensive jumper cables are. The jumper cables I have, I bought, I don't know how long ago. I don't even know. I don't remember how much they were. So, but I was thinking $41 for jumper cables seems expensive, but I have no idea. I honestly have no idea how much they are. So maybe they're that much. But yeah, definitely not $10. Like under $10. It was for like $3.50. Even worse. Under $5.
Which is 212089. I don't think you have a valid license. Do you have your license back?
Yes, Your Honor.
In the old days, it wouldn't have given you your license back with multiple unpaid tickets. I want you to pay that. All right, now let me repeat. If you hold up your end of the deal, this charge is going to be dismissed.
Sure.
If you don't, we can proceed to sentencing at that time.
Okay.
I want you to take this form out to the counter. They may send you downstairs to the probation department to get plugged into the economic crime class and the community service.
Okay.
Thank you, Melissa, for your help with those.
Take care. Make sure you get that stuff done. Like,
All right, that's it for that video. And yeah, when I started thinking about the price of jumper cables, I didn't look it up. But yeah, mine are old. Mine are probably 15 years old. I had them before in my last car before I bought my car. My car's 10 years old. So, all right, I got to upload the other video. I didn't do that yet. I'm such a great host. You guys love my editing skills and my hosting skills. At least I have good guests. Nunya, if you're still here, thanks again for last night. That was awesome. Sunday premiere. I'm such a good titler too. All right, I'm not going to make you sit through that. All right, I do believe this is all Judge Simpson. Just saying. So get ready for a lot of Judge Simpson. Okay, all caught up with everything. All right, let's go.
76343 on behalf of Ms. Scott, who's present to my right.
Yeah.
Say your name, Ms. Scott.
Here, Scott.
Thank you.
Judge, I recently substituted out her previous counsel, so I'm asking for an adjournment. I received paper discovery today from Ms. Isaac, and I requested digital discovery from her previous attorney and from the prosecutor's office.
All right. I don't have a problem adjourning it out. There is, and counsel, I don't know if you're aware, there's a bond violation report.
I am not aware, Judge. I think we substituted out on Monday.
She's on a Soberlink tether.
Soberlink tether or Soberlink blow?
Well, a Soberlink device. I
Okay.
call it a Soberlink tether. And she's missing her scheduled testing. On 2/4, she missed her test from 6 to 9, did submit a compliance test an hour and a half late. Then on February 16th, she missed her test, her 6 to 9 a.m. test, and did not do another test until 10 a.m. On March 15th, she missed her scheduled test from 9 to 12. She did submit a test nearly 2.5 hours later.
Judge, this is news to me just today. So
Oh, that's why I read it and
Yeah,
told you.
I appreciate it. It's my understanding that she's taken some medicine, anti-anxiety medicine, which
Makes me sleep.
makes her
I
sleep
apologize.
through, so she'll sleep through some of the morning things just because of her medicine. So I guess, is there another, can we? I don't know. Can I ask for one more chance? And
Why don't we do this? Why don't I give you a copy of this to look at, go through it with your client, and I'll call it back up, and then I can get a cogent argument as to do.
okay, thank you, Judge.
All right, that was part one. Now, I think I have one case in between those. I wanted to edit it and put together, but it was back to back, and it just made more sense to let the whole clip flow through. So remember that lady, remember that defendant. She will come back up. She will come back up. And this was the week or the couple days that Mr. Allen was off. So I saw your comment. I'm waiting for the Mr. Allen. So he has the female bailiff that just automatically goes and walks behind the defendant when she hears probation violation or bond violation.
That's not the case of the people versus Ayanna Johnson.
This is also a little bit more of a lighthearted video.
Bridget Coons on behalf of Ms. Johnson,
Just a
state your
heads
name
up.
for the record.
Ayanna Johnson.
Your Honor, this one also has a bond.
Oh, yes, it does.
So there is a few late tests, quite a few. I did speak to Ms. Johnson. She was under the impression that the test was supposed to be from 9 a.m. till 12 p.m. And that kind of does reflect on these missed tests, as almost all of them, or late tests, as most of them are submitted between the 9 to 12, it looks like.
Well, except for, no, I see what you're saying, but then on the 12th, she seemed to miss both. Like she missed 2 of her testing. Look on March 12th, the 6 to 9 a.m. was missed, and then the 12 to 3 was missed, and there was no retest on that one. That same thing happened on the 17th, where the 12 to 3, there was no retest.
Tater Tot, again, thank you. It doesn't get worse, but it does get funny. It gets funny. It was worth showing. It really was worth showing.
Okay. On March 12th, I do see one was submitted at 9:34. She gets off of work at
Right.
work.
No,
Yeah.
hold on. I just want to make sure we're clear. On the 12th, there are 2 tests. If you look at the very first 2 entries, the first test, it was a 6 a.m. to 9 a.m. test. She didn't test until 9:34. Then on that same date, there's a test between 12 to 3. That one she missed entirely
I see.
and didn't retest.
Well, I have had the opportunity to clarify the time. We anticipate no further violations. After all this, she has never tested positive once for alcohol. So we'd be asked that she be allowed to continue on bond, and then to adjourn this to allow more tests to come through to prove that she is a good candidate going forward for resolution on this case.
Is she really going to be able to do this? Because if I do that, any more missed tests, then she's going to go.
Okay, I just need to know what times I need to know the correct time.
Well, they gave you the time.
That's what I'm saying though. So that's on, they gave on the paper, it say from 6 a.m. to 9 a.m. and then one from 12 to like 3 o'clock. And then the other one say 9 to 12 a.m.
Well, yeah.
So I
Okay.
got my alarm clock set for 9 o'clock p.m., 1:30 p.m. and 9:30 p.m. That's not right.
So you're basically,
How do you think that's right? Your testing window is from 6 to 9, 6 a.m. to 9 a.m. No, 9:30 isn't right. I don't understand the confusion of why she's asking this question. I really don't. Especially if you wake up and you take a test at 9:30 and you think you're on time and you see that you have a violation and you're late. Okay. 9:30 is late. What do you mean? 9:30 is that late? Yeah, it says till 9. Come on.
Your alarm clock is going off a half an hour into the testing schedule.
Is it?
Well, I don't know.
I think. you
Okay,
need to-
look, ma'am, the test that you're missing, Miss Coombs is right. The 6 a.m. to 9 a.m. test fundamentally is the test that you're missing.
Okay, so I'm just taking it too late.
Yes,
Okay.
but that's a miss.
So you got to reset your alarm maybe to 9 or 8 a.m.
Yeah.
Or 7
Yeah.
or 6.
Yep.
Somehow or another, that 6 a.m. to 9 a.m. test you've got to get in.
Okay.
You're right, you do tests, but some of these tests are an hour and a half, almost 2 hours after the end of that period.
Okay.
And so what I'm saying is, I'll give you another shot, but you need to understand something. If I have another missed test, because I should really consider all of these tests positive. Okay. But if I give you that chance, if I have another missed test,
I'm gonna go to
then I got it. Yeah, I got to do what I got to do. Now, the other option is I can switch you over because of this violation. I can switch you over to a scram test.
What is that? On my ankle?
Yes.
Why are you yelling at me?
I'm not yelling.
I'm giving you, normally I don't give options. I don't know why I feel so generous today. I know, it's like unusual.
Because all of her tests are coming up negative. She is missing tests, but she's making her tests later in the day. It's just the first one, and they've all been negative. And she showed up to court. She's somewhat charming, kind of borderline respectful because some of the things she says, but it's not in a disrespectful fashion. Yeah, so I understand this. But yeah, Judge Simpson is being lenient because she is testing negative. She doesn't have a positive test.
On your ankle, you don't even...
Usually if I had a report like this, ma'am, I'm going to tell you you'd be going to jail right now.
Okay.
So what would you like to do? Take the chance that I let you go and you test on time, or you want to scram test?
Is that gonna dig into my ankle and how do that work? I don't know what that is, so I gotta ask.
They put it around your ankle, and then if there's any alcohol consumption, we're gonna know.
How long I gotta wear it?
I guess the best answer until I say you don't. I know this is hard because
I can't walk around.
I know fashion. Go girl.
Yeah, I can't walk around.
I mean, I don't know.
Tether on my
What do you
ankle.
want me to say?
I'll just do the blow.
Really?
Yeah, I'll do it on time. I'm gonna change my alarm. I can't walk around with no tether.
Really?
I mean, if I ain't got no
you
choice.
could.
I mean, I could, but if I got a choice, I'd rather blow.
I know. Emily, your tether didn't go with any of your outfits, did it?
Like what?
I'm sorry. I'm just. Okay, I'm sorry, Emily. Didn't mean to let that out like that. Defendant to have no further missed tests. When did you want this adjourned out to?
Can we have a month?
And I'll adjourn this. You gonna make it a month? What? Why are you looking at me like that?
I'm gonna make it.
I'm just at. Okay.
I'm gonna make it.
No, I'm gonna put it in the file. She said she's gonna make it. Then when you don't, if she doesn't make it, don't be begging me to do anything different. I gave the warning.
Thank you. What was the date on that, Your Honor?
Seriously,
Sorry.
May 1st.
Thanks.
Thank you.
You're welcome.
All right, yeah, that one. I think she's gonna do just fine. Set her alarm. She'll be all right. But Sparkle Poots, thank you so much for the 5 gifted memberships. I appreciate it, and welcome to all the new members. Thank you, Sparkle Poots. Okay, I feel like I had something else I wanted to say. That must not have been that important. All right, I think this is when we recall the first defendant. I told you to remember. Told you to remember her.
I think though that if you get a black outfit, the tether goes. It's okay. I'm just saying. Court recalls the case of the people versus Sheriff Scott.
Judge Patrick 9 has P76343 on behalf of Ms. Scott. State your name, please, Ms. Scott.
Here, Scott.
Judge, so thank you for informing us about the bond violations, but we have.
You're welcome.
She admits that she missed them, but she has been seeing a mental health specialist to get on medicine to help with her panic attacks. She's been on it for about a month. She complained last week that they were making her tired. And the reason she got on them is because she wasn't sleeping well and was having panic attacks. So that's why we believe she was missing the test, because she couldn't get herself up and stuff. So just like the last person, assured me that she won't.
So counsel has learned.
Yes. Well, usually I'm on Zoom in front of you, Judge, so.
I know. We were actually mentioning that because I've never seen, I don't think you've been in person.
No.
No. But go ahead.
So I'm asking to give her another chance, asking for adjournment. I think we're going to get close to resolving this case by the time we come back. Like I said,
Okay.
have discovery.
In all seriousness, they're adjusting your medication. So,
And to be honest, she's only been on it for about a month now. So the first
right.
tests were.
And so my concern is just like, well, not quite like the last person, but I can do this, but if you miss another test, we're going to have a problem.
Understood.
Or I can switch you to scram.
I'm okay with the blow. I'm
You're okay with?
blowing in the Soberlink, Your Honor.
Did you hear that, Rachel? We found him. That's where he's been. That's where. Yep, Rachel. That's where he's been. I didn't know. I didn't realize he, moved to Michigan and got his law license, law degree. But that answers a lot of questions.
You don't want to.
I'm with her with the whole ankle thing, because like if I go to work and then it just don't, I can't wear a dress.
Is that true? Okay, all right. I'm just checking. Let's do it this way because your circumstances are a little bit different. Okay. I'll adjourn this to the 17th at 9. Then will that work, counsel?
April 17th at 9 a.m.?
Yes.
Yes, Judge.
Or whatever time whatever block you get it put into. Defendant to have no further missed test. All right. If you're still going through the medication protocol, if there are missed tests, I'm going to need some documentation of something. Otherwise, I'm going to follow normally what I do. Understood, ma'am?
Yes, sir.
Okay. All right.
Thank you very much, Judge.
Thank you.
See you live in about 2 weeks.
Yes, sir.
All right. 2 people got off light for missing tests. We'll see. They're both up this week, I think. Well, no, at least that last one's up this week. We'll see. We'll see. All right. We're still in Judge Simpson's court. I just don't really remember what's next.
On jury trial, April 22nd. 2024, 9 a.m. in person.
Thank you, Your Honor.
Thank you.
Oh, I was wondering where I started. Usually I edit those parts out. But there you go.
Oh, no, it's my second, but I.
Court calls the case of the people versus Marcus Moore Jones.
The people. Bridget Coons on behalf of Mr. Moore Jones, state your name for the record.
Marcus Moore Jones. Keep your hands out of your pockets. Thank you. All right. What are we doing?
Jenner, Mr. Moore Jones is going to plead today, plead guilty as charged with HIDA offer.
And that's correct, Your Honor.
Raise your right hand. You solemnly swear or affirm testimony you're about to give will be the truth, whole truth, and nothing but the truth, so help you God.
Yes, sir.
State your name for the record.
Marcus Moore Jones.
Keep your hand out of your pocket, please. All right. Thank you. Sir, it is this court's understanding. You can put your hand up. This court's understanding you're going to plead guilty to the charge of receipt and concealment of stolen property, 200 to 1,000. That is a misdemeanor punishable by up to 1 year incarceration, a $2,000 fine plus court costs. Fine can be increased to 3 times the value of the property receipted and concealed. If that's greater than $2,000, that would become the maximum fine. You understand that?
That's right.
Understanding all of that, you still wish to plead guilty? And to that charge, how do you plead?
Guilty.
You understand that by pleading guilty, you'll not have a trial of any kind.
Yes, sir.
You signed an advice of rights form today? Any question regarding any of those rights? Look at, there's a copy on the podium. Look at paragraph 5. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right. Are you on probation or parole? All right. Were you on probation at the time of this offense? In June of 2023?
I don't believe, no, I wasn't at the time.
You weren't? Okay. Has anybody promised you anything other than what's been stated here?
I'm not saying you're right, but we're all thinking it. We are definitely all thinking it.
Here today on the record to get you to plead.
No, Your Honor.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily?
Yes, Your Honor.
Of your own free will?
Yes.
Because you believe that you are guilty?
Yes, Your Honor.
If I told you that if you put your hands in your pockets again, that I'd throw you in jail, would that stop you?
Yeah.
Yeah, okay. You just need a little encouragement, right? Okay. June 22nd, 2023, at the location of 4133 Washington Avenue, Pittsfield Township, Washington County, State of Michigan. What do you do that makes you think that you're guilty of that offense?
I had possession of the golf club.
Okay. How'd you come into possession of golf clubs?
I bought them.
You bought them? Okay.
Was the cost so low that it would make a person believe, or did you believe that they could have been stolen?
Yes.
Okay. You had reason to believe that they were stolen.
Yes.
When you bought them. All right. And the actual value of the golf clubs was in excess of $200?
I believe so. Yes, Your Honor.
Okay. Would you stipulate that it was
Yes, Your Honor.
greater than $200? All right. Counsel, have I complied with the court rule? Would it be proper to accept this defendant's plea?
Yes, Your Honor.
Yes, Your Honor.
Court will accept the defendant's plea of guilty to this charge. Defendant is referred to probation for pre-sentence investigation and report. Sentencing in this matter will be May 8th, 2024, 9 a.m. Bond will continue. You can stop by probation, right? It's on your, it'll be on your left on going down the hallway. Okay. Okay. So you can get that process started. Okay. All right. If you wear a belt, man, you wouldn't have to do. All right. I'm just saying. I'm a bit old fashioned. You put a belt on, you don't have to put your hands in your pocket to hold them up. Take care. Yeah. All right. Yep. Not only a judge, I give fashion tips.
All right. Yep. Yeah, we all knew that was coming. All right. Let's see. This last one's only about 2 minutes long, so I'm gonna let it play out. I think I'm all caught up on. Yep. So thank you, everybody. Thank you for hanging out. Thank you for all the super chats, the memberships, the membership milestones, the gifted memberships. Thank you to the mods, as always. You guys are awesome. Thank you, everybody, for tuning in. If you haven't hit that like button already, please do so. It helps me out a lot. And if you're not subscribed for some reason, do that as well. That also helps me out a lot. I will be in Discord for a little bit tonight, so let's go hang out in Discord. Yeah, that's all I got. We're gonna watch one last about 2-minute clip from Simpson, and then we're out. I'll see you guys all tomorrow. Membership Monday. I'm gonna have to make it a really long membership Monday. Because I didn't do one this week, and I kept saying I was going to, and I didn't. Maybe I'll just do 2 membership. I don't know. I'm gonna stop promising things and not doing them. But we will have a membership Monday tomorrow night. All right. I'll see you guys in Discord. Bye. Discord link is always in the description. Just so you guys know. You just go to scroll down in the video in the description. You'll see it.
Case people versus Bilal Howard.
Mr. Riser, on behalf of the people. Bridget Coons on behalf of Mr. Howard. State your name for the record.
Bilal Howard. Thank you, sir.
Your Honor, we'd be looking to set this one up for final settlement.
Jury final settlement conference will be set for June. You know, how many people have I taken into custody today?
One.
Just one?
Yeah.
There was almost 2. And I tried so hard.
Yeah, I had to put this in after that happened in this video. Again, this was supposed to be a premiere. It was all going to be Judge Simpson. So in my mind, that all rolled together. But I did give it a pause because Sparkle Boots, called me a liar, and she's right. I am a liar because I didn't let it play out. Thank you, Sparkle Boots.
I'm proud of me.
Good job.
June 7th, 2024. Mr. Howard's like, he's not talking about me, Mr. I said I could see him sweating. June 7th, 2024. That's at 9 a.m. Jury selection, sir, will be June 10th, if necessary, 2024 at 8:30. Both of those proceedings are in person. All right.
Thank you.
Thank you.
Woo, you got it in. You got it in right before the outro. Thank you, Legal Fiction. That was 2. And unless someone's typing in right now, it's probably not going to come up again. So you guys have a great night. See you in Discord. All right, let's raid. We can do a raid. Since everyone seems to be obsessed with the new judge, and I haven't really seen him yet, so how do we do this again? What button? Is it this one? Oh, it's not coming up. She might not have raids turned on. Let me see. Yeah, I know we're paused. The video's over though. But I'm just trying to set up a raid. Yeah, my YouTube is really slow right now. All right, let's see. Okay, let's go hang out.